Not every judge or attorney actually knows this. I've had to actually remind judges in the past, hey, I don't need a change of circumstance for us to readdress bail. Hi everyone, Attorney Joe McPeak with Virtuoso Criminal and DUI Lawyers. Today I'm going to talk about California Penal Code section 1270.2. That's the first court date if the judge decides to hold the defendant on a bail they can't afford. Can you convince them to lower the bail or maybe have you released on some sort of special conditions or both? This section allows the defendant in a criminal case to challenge a judge's bail decision. It says that once somebody is detained in custody for want of bail, or because they can't afford the bail that's been set, that defendant is entitled to an automatic review of the judge's decision within 5 days. What this means is the defendant gets not one, but 2 bites of the apple at the initial stages of the case in the same court. It doesn't require you to file an appeal to a higher court. They're entitled to a review of that decision within the same court they're already at. This is really important because at the first court date, a lot of times the prosecution has an unfair advantage maybe when it comes to discussing bail. They definitely have an advantage. Some people would argue it's unfair. I would certainly say it's totally unfair without the provisions of 1270.2. But in any event, the prosecution at the first court date has probably had a lot more time to read over the police reports, to go over the evidence they're using to base the case against the defendant. After all, they're the team that decided to file the case. They're the ones who have the more direct interactions with law enforcement. And this is important because going into a bail hearing, the judge is supposed to start off by assuming the allegations against the defendant are true. And then when we start with that, where does it leave us when it comes to the calculation of public safety, the risk the defendant might flee, things of all that nature? It's really hard to have that conversation fully and fairly unless both sides have had some equal opportunity to review the evidence that is being used against the defendant. This automatic 5-day review from the first court date guarantees that the defendant will have at least some ability to go over what the case is actually about before having some intelligent and potentially final discussion of bail in open court. What's important also is that in order to revisit bail under 1270.2, you don't need any change of circumstances. The phrase change of circumstances comes up a lot in discussions on bail. You might sometimes hear if you happen to be sitting in court and watch a bail hearing go down, you might hear a judge inquire to defense counsel, why should I adjust the bail? There's no change of circumstances from last time. A lot of times you need to have some sort of change of circumstances to readdress bail. Otherwise, people would just re-raise bail willy-nilly all the time, maybe in front of different judges that they liked better than others. And the law doesn't like to have the idea of forum shopping, or at least they don't want to encourage it. So what 1270.2 does is it allows you to revisit bail after having a chance to actually grasp the case and look at the evidence against you with your attorney for at least a couple days, and also keep it on a short leash so that they can't just make you wait forever, go to the back of the line while you're sitting in custody to revisit bail. It gives you that opportunity to readdress bail without any change of circumstance. I can say from personal experience, not every judge or attorney actually knows this. I've had to actually remind judges in the past, hey, I don't need a change of circumstance for us to readdress bail. Now that I'm here and we have a better grasp of the facts, I can re-raise the issue, and that forces the court to make a new decision. And that is important. You don't need a change of circumstance to readdress bail under Penal Code section 1270.2. It is not required at all, nor should it be. So, what could happen after this bail review? Well, hopefully, your lawyer can actually get you released on some sort of bail you can afford, maybe combined with some sort of non-monetary conditions. Maybe in those intervening 5 days, everyone has realized that the allegations are actually a different type of severity than anticipated, or maybe not as serious at all, such that some sort of release is actually warranted. If, however, the judge unfortunately does not release you, well, then your other remedy to readdress bail is either to A, wait for some sort of change in circumstance to actually arise, B, to go forward to a preliminary hearing, where at the preliminary hearing you're entitled to another review of bail, even if you do end up getting held to answer on all of the charges there. May not be the best look right there, but you are entitled to that review. Or third, you have something called a Habeas Corpus petition. Discuss with your lawyer whether that is viable. If there's any legal errors that maybe the court made in setting your bail or denying your bail, that may be some sort of appeal to a higher court called a Habeas Corpus petition, might be the best and most sensible thing to do. One other thing that's of note is that 1270.2 literally says it applies to defendants who are held for want of bail, meaning they're held because they can't afford the bail that's being imposed. It is understood, however, that this also applies to no bail orders or detention orders. So if you're held on no bail at all, or just a bail that's just too high out of your price range, either way, the provisions of Penal Code 1270.2 do in fact apply to you, and you are entitled to that automatic review within 5 days. If the first court date doesn't go your way on this issue, please make a point to discuss with your lawyer whether review under 1270.2 and other steps that I discussed in this video may be applicable and may be sensible in your case. These are all things that are worth discussing if you or a loved one are detained while the case is pending before being found guilty. It's really important to see whether there's any other viable avenues available to get released from custody so you can fight your case from the street, as we say. It's always better to prepare and defend your case while you're free than it is from in custody. And that is always something that you should be discussing vigorously with your attorney.